You may proceed.
Good morning, Mr. Casey.
Good morning, sir.
I'd like to show you Defense Exhibit FV, if I may approach the witness.
You may.
Do you recognize that map, sir? I can.
If it's attached to an email, is that correct?
Yes, it is. May I show the witness Defense Exhibit FU?
Yes.
Thank you, sir. Yes, sir.
Is that an email that you sent on November 15th, 2008?
That would be correct.
Okay. And taking a look at that map, does it fairly and accurately depict the locations where you searched?
Well, okay.
I think you can answer.
You can ask.
It would be a fair and accurate representation, although it would not be specifically, but it's within.
Okay. And are there pin marks there?
Yes, sir, there are.
Okay. And does it show the location where you searched? The pin?
Where I looked in?
That's a Google map, is it not?
Yes, sir, it is. I pulled up a Google.
Okay. And then you did a pinpoints?
No, actually, I'll tell you what happened. To the best of my recollection, Luke sent me an email with this and asked me if I could point on there, onto here,
Where you searched?
where I looked onto Suburban Drive.
Okay. But before we go any further, Judge, I'd like to admit into evidence. Defense FB.
What says the state?
I'm just citing the state's previous objection.
Objection overruled. Be received in evidence as defense exhibit.
Number 73.
Now, sir, this map was prepared in November of 2008, correct?
Yes, sir.
Either the same day or right around the day that you actually searched this area?
I believe the email.
Not identify himself as creating the map.
He did. He said he put the pinpoints on there. He sent the map and then he put the pins of where he searched.
Overruled at this point. Go ahead, sir.
Now, sir, my point is, where you had searched was much fresher in your mind on November 15th, 2008 than it is now 3 years later, correct?
Oh, definitely so, yes.
Okay. And this is a map that was pinpointed right about the time you did the actual searches.
That would be one that was sent to me by Luke on November the 15th.
My question to you, when did you go out to Suburban Drive to search? Do you know the exact dates?
Yes, sir.
What dates?
November the 15th, 2008.
And the 16th?
November the 16th, correct.
Okay. So this was emailed the day that you actually searched there?
It was sent to me via email that night after Luke called me and said, Jeanette wants to know.
Sustain.
Just listen to the question, sir, and just answer the.
Okay.
November 15th, you searched. Is that a yes?
November the 15th, I went to the location and walked around. That is correct.
Okay. And November 15th at 7:51 p.m., you sent this email.
Yes, sir.
Okay. Now, I'd like for you to look at Defense 57 and this email and verify that the pins are at the same locations, if you can.
Okay. Yeah, I'd say they're within the same range. But however, with this being blown up here, this is,
This is the blown up map of that.
yeah, this will be inaccurate though.
What would be inaccurate?
Let's see it because it was closer to the bend.
Okay, but is this? Is this map a blown up map of this? Does it appear to be the same map?
It appears to be a blown up version. And when I see the blown up version, the pin mark should be closer to the, it was more at the bend.
Okay.
So is that what it's showing? If that's what it's showing there, then that would be true.
Now, sir. Everything you've testified in this case so far, obviously, is further in time than November 15th, correct?
Yes, sir.
May I publish this to the jury, Your Honor?
Got some evidence?
Yes.
You may.
Start over here. The first pin, sir, is the location off Suburban Drive, correct?
The one on the south
One on the
side?
left, and then abandoned house.
Yes, sir.
Okay. I have no further questions.
Cross-examination?
Thank you, Judge. Good morning, Mr. Casey.
Good morning, Mr. George. How are you?
I'm fine, sir. Thank you. When you dropped or marked this map, Defense 73, with a pin, you weren't being precise, correct?
No, I wouldn't say it's an exact representation of where it was the best guesstimate.
It's a very general area of where you searched, correct?
Where I went, correct.
Where you went.
Yes, sir.
All right. And Defense also showed you the blow-up of Defense 57. And you had indicated that, make sure I have this correct, where you searched on Suburban Drive was closer to the bend in the road, correct?
I used the bend in the road as the reference point.
Sure. And that,
So,
I'm sorry, I didn't mean to interrupt you.
no, I apologize. And on the smaller, the 8.5 by 11, you can't, the 8.5 by 11 inches paper. When you look at that and then you look at the larger one, it brings it more into a perspective.
I'm sorry.
No, I
I
apologize.
think you're done.
Now, as far as that pin goes,
Yes.
okay, I do recall that from the bend, okay, if you headed west, which would be toward you, okay, I probably came in, walk into the woods, that'd be headed south, and you walk in, say, 20, 25, 30 feet, plus or minus, and then took a right turn, because it was open. That was the open area that you could walk. And I probably walked maybe 20, 30, 40 feet. So I would have been walking towards that green pin.
But the general point is that these pins aren't indicative of exactly where you went, correct?
No, sir.
Is that correct?
That is correct.
All right. So what we talked about a couple of days ago, when I showed you the pictures, the ground level view, you were able to tell us, thank you, you were able to tell us where you exactly were, correct? Or the best guess
To the
at
best
that
of my
point.
knowledge, 3 years later, yes.
All right, so this map doesn't really help you all that much, does it?
Well, it is one that I put the pins in.
Right, but as you just indicated, this is a very general idea of where you went into the woods, correct?
Yes, as that would be.
Okay.
Yeah.
Thank you. Thank you, Mr. Casey. Thank you, Judge. I have nothing else.
Thank you.
Any,
This is something you prepared 3 years ago,
Yes, sir, that would be true.
the day you searched out there.
Absolutely.
Would you agree that Orlando is 101 square miles?
Would I agree with that?
Yeah, that's the size of Orlando.
If you say it is, I'd agree with you.
Okay. And this is the only place where you searched for a deceased Caylee in the entire 101 square miles of Orlando.
That would be the only place that I went to, that one on the south side and that one on the north side.
So
That
the
would be
answer is
correct.
yes, right?
Yes.
No further questions.
may the witness be excused? Yes, sir. Thank you, Mr. Casey. You may be excused, sir.
Thanks, sir, very much.
Relates to defense FS.
You offering that in evidence?
Yes, sir.
Any objections from the state of Florida?
No, Your Honor, I believe the stipulation bears my signature.
Hand it to the clerk so she can remark it and be received in evidence as defense exhibit.
Number 74.
Ladies and gentlemen of the jury, the following is a stipulation between the state of Florida and the defendant. The attached video is a true and accurate copy of a news video taken during the first week of August 2008 depicting the command center manned by George Anthony located at 4466 North John Young Parkway, Orlando, Florida 32804. The parties have agreed to this fact and it should be considered as true in your deliberations, bearing the signature of Mr. Jose Baez and the defendant and the replica and symbol for the signature of Ms. Linda Drain Birdie.
I think we have her original signature.
That's the copy, that's not the original.
Well, I'm just reading what was given to me. All right, this one here bears her actual signature. You may publish the exhibit.
Just making sure the audio feed was cut. All right, double check.
You're publishing it now?
He's about to, yes.
Well, you need to put it so it'll go on the screen.
Oh, hold on. Okay. Pause it. That concludes the video, Your Honor.
Thank you. You may.
Your Honor, the defense calls George Anthony.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
George Anthony, George Anthony.
You may proceed.
Mr. Anthony, did you just see the video that was presented?
Yes, sir, I did.
And did you see the duct tape that was there?
Yes, sir.
That was your duct tape.
Could have been someone else's. I have no idea, sir.
That could have been somebody else's duct tape?
Yes, sir.
Asked and answered.
Sustain.
Did anyone during the time at the command center bring duct tape to the command center?
Which command center, which location, sir, are you talking about?
The location that was shown in the video.
Which location is that, sir?
I can have a moment. Sir, you didn't recognize that location in the video as being close to your home.
Sir, I'm asking the location, sir. We had numerous command centers that moved around.
4466 North John Young Parkway in Orlando.
No, sir, we never had one there.
Okay. So where was that video taken then?
Sir, I'm just commenting about the video you're talking about. I have no idea where that was taken at, sir, but it wasn't on John Young Parkway.
Okay. So was that a Publix where you were at in that video?
Yes, sir, that was at Publix.
Okay. Do you know which Publix that was?
That particular one, no, sir. We had different locations we went to.
How many different Publix did you go to, sir?
At least two that I can remember.
Okay, so there's two. There's not 50.
I just answered you two.
Okay, where are these two locations?
There's one on Chickasaw, North Chickasaw by Lake Underhill. There's also one at Chickasaw that we had by Curry Ford Road.
Do you know which one of those two that video was taken at?
Not at this time. No, sir, I don't.
And at that location, at that time, in the first week of August 2008, where was your command center?
We had one at the corner of Lake Underhill and Chickasaw, North Chickasaw.
Okay. At that location, did anybody else bring Henkel brand duct tape to your command center?
I have no idea, sir.
You have no idea.
I have no idea.
And you have no idea if that's your duct tape.
I have no idea, sir. I just answered that.
Okay. Sir, I'd like to ask you if when you came from Ohio, right?
Yes.
That's the same place Henkel brand duct tape is made, right?
I have no idea where it was made at, sir.
Okay. And when you lived in Ohio, sir, did you have a dog named Mandy?
Objection to relevance of having a dog in Ohio.
I will be tying it in.
I would like to approach
Approach.
that relevance of that.
Objection overruled.
Did you have a dog named Mandy in Ohio, sir?
Yes.
Okay. Did there come a time where the dog had to be either put down or was deceased?
Yes.
Okay. And how was that dog buried?
In our yard where we used to live at.
Okay. Did you pick the dog up at the vet?
Yes.
Okay. And was the dog wrapped in a blanket?
To the best of my recollection, probably, yes.
Was the dog then placed in a plastic bag?
I don't remember that exactly, but the dog was deceased and the dog was taken to our home and placed there. Yes.
Was it also wrapped in duct tape?
Sir, I have no idea. You're going back almost 30 years here, sir. 25 to 30 years.
And was that before Casey was born?
Yes.
When you moved here, did you have a dog named Bo?
Yes.
And how was Bo buried?
Objection, could we have a point in time?
Sure. I'll
Sustain, rephrase the question.
When did Bo pass away?
I can't remember the exact year, sir.
Okay. Was it 15 years ago? 10 years ago?
Could have been 15 or more years ago.
Okay. How old was Casey at that time?
Somewhere in the neighborhood, probably about 4 or 5 years old. I'm just roughly guessing here.
Okay. And was Bo buried in a blanket in a plastic bag wrapped with duct tape?
I do not remember him exactly what he was exactly buried in, since why we took him to a veterinarian because he was in distress. He was dying.
Okay. Did you have a cat named Penny?
Yes.
Was Penny buried in a plastic bag with duct tape wrapped around?
No.
What about Ginger?
No.
Is that a dog or a cat?
That's a dog.
Okay. Was Ginger wrapped in a bag with duct tape wrapped around it?
I don't remember exactly how our animals were finally put to rest. I can't answer that exactly precisely to you.
What about Cinnamon?
Again, that'll be the same answer.
Okay. And Misty?
Never had a dog, Misty.
Okay. When you found out that your granddaughter was found and with a blanket and with a plastic bag and with duct tape, did you tell law enforcement at any time over the last 3 years that that is the way you used to bury your pets?
Objection, improper impeachment.
Yeah.
I have no further questions. Sorry.
Objection sustained. You have no more questions. Thank you. Mr. Ashton?
Mr. Anthony, have you ever taken a dead pet and thrown him in a swamp?
No, sir.
Overruled. May the witness be excused. Thank you, Mr. Anthony. You may be excused, sir.
Thank you, sir.
Cynthia Anthony, Cynthia Anthony.
You may proceed.
Thank you, Your Honor. Good morning, Mrs. Anthony.
Good morning.
Mrs. Anthony, did you have a dog named Mandy in Ohio?
Yes, I did.
And that was 20 plus years ago?
I got her in 1981.
Okay. Would that have been before, when she passed, was Casey alive?
Yes,
Okay. A baby?
yes. She was a toddler.
Okay. And did there come a time where you took Mandy to the vet because she was either dying or had to be put down?
Yes, I took her.
And how was she wrapped, or do you know the circumstances surrounding that, how she was buried?
Yes, I made an appointment to take her. She had been very ill, and I knew she was going to be placed down because that was a conversation before I took her to the vet. And they told me to bring something that I might want to put her with, like a stuffed animal or a blanket or whatever. So I brought a blanket that we actually had. She was my first baby, actually, before I had the kids. And so you know how pets become your babies. And I had bought a baby blanket for her. So that blanket I took with her to the vet, and I was holding Mandy when they gave her the injection. And then they took her from me and the blanket. And I don't know how they put her, but I received her back. She was already wrapped. in black plastic with like packing tape over it.
Okay. Was it duct tape?
No, sir.
Okay. And did you have a dog named Bo?
Yes.
And that was when you moved here to Florida.
Yes.
And when did Bo pass away?
The summer of 1990.
Okay. And how was Bo buried?
We buried him in the backyard.
Was it also with black plastic bag and duct tape?
Again, Bo was taken to the vet, and I was at work. Georgia and Casey took Bo to the vet when he was in distress, and he actually died on the table while the vet was looking at him, and the vet secured him. And then later that evening when I got home from work, he was already ready to be buried. So George and I and the kids had a little ceremony in the back.
Okay. And how old were the kids?
Lee was in first grade, and Casey it was our first summer there. So I think she had just had her 4th birthday.
And was the bed buried in a plastic bag with tape wrapped around?
I believe it was in black plastic. I'm not sure if it was a bag, but it was black plastic, and again with tape.
Okay. And did you have any other pets that were buried that way?
Well, there was no other pets that the vet had secured for us. The rest of the ones we did on our own.
Okay. And how would you do those?
Pretty much the same way. If we didn't have a blanket or something, we had like a towel or something that we would use, like if we gave them a bath or whatever, a special towel that we had set aside for them. Ginger, Cinnamon were buried with a towel. And then I think we may have put a favorite toy with one of the Cocker Spaniels. And then we put them in a couple layers of plastic garbage bags and then wrapped them with clear packing tape.
Okay. Did you ever tell me that they were wrapped in duct tape?
Your Honor, objection.
I'll withdraw the question.
Sustained.
I'll withdraw the question. Are there any other, would that be the rest of the pets that you had were all buried the same way?
Penny, my cat, in 2009, he passed, and I put him in actually one of Caylee's hooded bath towels. It was very special to me, and I placed him in that and then put him in the plastic bags and then wrapped him with packing tape.
No further questions.
Cross-examination.
Thank you. Good morning, Mrs. Anthony.
Good morning.
I take it that you did not euthanize your own pets with chloroform.
No, ma'am, we did not.
This is
We're
beyond
talking
the
about
scope.
how the animals became deceased.
Sustained.
Did you put duct tape on any of the animals' faces prior to their burial?
No, ma'am.
Cinnamon and Ginger were 2 Cocker Spaniels,
Yes, ma'am.
mom and baby,
Yes, ma'am.
and they passed away within 6 months of each other, correct?
Approximately.
Okay, the first in the fall of 2003, is that accurate?
I think so.
And the other either in the winter or spring of 2004.
Yes, ma'am.
Your daughter Casey would have been a senior in high school at that time, correct?
Yes.
And Casey assisted you in wrapping either Cinnamon or Ginger or both, correct?
I believe she was present. I think it was George and I that actually wrapped the dogs.
Well, the reason for putting the tape around the bag was so that the bag would be compact for burial, correct?
Yes.
And you said this was a family tradition, correct?
Pretty much to have them. I mean, we started out, I buried Mandy in our backyard in Ohio. And if we would have stayed there and had more animals, we would have probably had one spot. And when we moved to Florida, we designated a spot at our home that, you know, if any of the animals passed, we would put them there, if possible.
But this is something that your family did for a period of years that your children were aware of, correct?
Yes, and we even had a dog, not really a headstone, but George had found a dog made of stone that we kind of marked the spots.
A little memorial marker in the
Yes.
yard for
Yes,
the dog.
ma'am.
All right. And was Casey present when the dogs were buried?
I'm not sure if she was present for Cinnamon and Ginger, both of them, but I believe she was present at one of them. And I know she was present with Bo. She was not present with Mandy.
Okay.
And
That
not
was
with Penny.
2009. Or that was the late 80s.
Yeah, that was in the 80s because she was little. I had her with neighbors. George was working, and I came home and buried her by myself because I didn't want the kids.
Right.
They didn't even know she was put down. I wanted to wait and tell them.
All right. But definitely by the time she's a senior in high school, she was aware of the burial and the method of burial in the yard.
Yes, ma'am.
That's all I have, Your Honor.
Redirect.
The tape was used to secure the top of the bag so it wouldn't open.
The tape was placed around the bags in two locations, the top and the bottom, so that when we rolled it to keep the air out so that, you know, we were trying to keep things from getting into the bag. So we placed tape like at thirds, like 1/3 and 2/3.
No further questions.
May the witness be excused.
Yes.
Thank you, ma'am. You may
Thank
be
you.
excused.
Lee Anthony, Leeanthony.
You may proceed.
Thank you, Your Honor. Good morning, Mr. Anthony.
Morning.
Were you present? How old were you when Mandy passed away in Ohio?
Very young, 3, 4.
Okay. Do you even remember that happening?
Not in particular, no.
Okay. When was the first time that you remember having your family having to bury a pet?
I don't remember being present for Bo. I remember that we had to bury him, but I don't remember being present for him. Same goes for Ginger. I wasn't here, but I was here when Cinnamon was buried.
And how was Cinnamon buried?
I buried her in our backyard.
Okay. Was she in a plastic bag with duct tape?
She was in a black plastic bag, and I do recall there being duct tape used to secure the bag.
Okay. Duct tape wasn't used. Oh, I'll withdraw that. Were there any other pets that you were present for the burial?
The only other pet that I was present for a burial was one that my grandmother had. Similar circumstances, but that was given to us by the vet. No other family pet that I can recall being present for the burial, or if I was too young to remember.
And how was that pet given to you from your grandmother?
My grandmother's, it was also in a black plastic, like garbage bag. It was taped. I believe it was more of a clear tape. And it was very cold. She was kind of on ice until we picked her up.
Who was in charge of burying your family pets?
Typically would have been my parents.
Okay. I have no further questions.
Cross-examination.
None.
May the witness be excused. Thank you, sir. You may be excused. Okay, let the record reflect that the defendant is present, along with counsel for the defendant, Assistant State Attorney. Both sides ready to proceed.
Well, actually, we do have to.
Your Honor, before we broke, there was reference to the state producing to us this morning a stack of records related to employment records of Miss Cindy Anthony. Do you recall that? And we, of course, objected, and there needs to be a Richardson inquiry about that. So I don't know whether you want to do that now or before they, what their plans are. Ours are as we told you.
Well, let's finish with your end, and then we can take up their end if they have rebuttal.
Can we approach briefly without the court reporter? We just want to.
Yeah. Okay, Mr. Baez, do you intend to present any more live witnesses?
No, sir, we do not.
Okay. Will the defendant be testifying?
No, sir.
Okay. I have some questions I need to ask of your client.
Yes, sir.
Ms. Anthony, do you understand, first of all, is it your decision not to testify based upon consultation with your counsel?
Yes, sir.
You understand that your decision to testify or not testify is solely your decision and your decision alone?
Yes, sir.
And it is your decision not to testify?
Yes, sir.
Have you had ample time to discuss this matter with your attorneys, that is, the pros and cons of testifying or not testifying?
Yes, sir.
And has anyone used any force or pressure in making you arrive at that decision?
No, sir.
And that decision is your decision freely and voluntarily?
Yes, sir.
Okay, thank you, ma'am. All right, let's return to jury. Mr. Baez, you may proceed, sir.
Your Honor, we'd like a stipulation that we have read into the record
Okay.
and introducing the accompanying documents.
Stipulation between the state of Florida and the defendant. The attached documents are true and accurate records of the business records for Surtec brands. The parties have agreed to this fact, and it should be considered as true in your deliberations, bearing the signatures of Linda Drain Burdick, Jose Baez, and Ms. Caylee Marie Anthony. Is this stipulation true and correct, Ms. Burdick? And as a result of that stipulation, do you intend to offer some documents?
Yes, sir. We intend to introduce the business records of Sure Tape, the Henkel brand duct tape.
And that is currently marked as identification numbered what, Madam Clerk?
FW.
And the defense offering that in the evidence, there being no objections from the state of Florida, it will be received in evidence as defense exhibit numbered.
Number 75.
Okay, Mr. Baez, you may call your next witness.
Your Honor, the defense rests.
Ladies and gentlemen of the jury, there are going to be some matters we're going to need to take up outside of your presence. It should not take too long, but I'm not going to run a guesstimate on how long it will take. So we will get back with you as quickly as possible. Please do not discuss this case among yourselves nor with anyone else. And please remember all of my previous admonition. Let's excuse the jury. Does the state intend to present rebuttal testimony?
We do, Your Honor, and the estimated time for that is less than a day.
Okay, there is a issue that the defense has raised dealing with some discovery. Mr. Baez, would you present your concerns about this issue?
Your Honor, Mr. Mason will be handling the argument for that issue.
Mr. Mason?
Your Honor, yesterday afternoon, the counsel advised us that they were expecting some records, some documents to be coming in from somewhere regarding the employment/work records of Cindy Anthony, and for the obvious purpose of attempting to impeach her testimony as to whether she was at work or not at work on the time that she testified that she had made herself the computer inquiries regarding chloroform. And they then this morning did present us with a few hundred pages of records of some kind regarding various people. And we're objecting to this testimony on the basis of a clear discovery violation. Miss Anthony's testimony was not new or a surprise. In fact, she had testified in deposition regarding various things, including this issue, back, and I'm looking for the date here, July the 28th of 2009, almost 2 years ago. They knew since then that Mrs. Anthony, Cindy Anthony, had disclosed that it was she believed had made those computer searches. And yet, having that information, they waited until after we called her to testify regarding that which is consistent with her prior testimony, and then subpoena records for the first time to come in and show us now. That is a discovery violation. It is prejudice to the defense because we have already, relying on the case history and the sworn testimony, called Miss Anthony to testify regarding her search and her records and so forth. And in fact, counsel for the prosecution cross-examined her on that issue and then goes out apparently and obtains witnesses from this company and bring in business records or whatever to now impeach that testimony. So we are indeed prejudiced by that discovery violation. And as a result of that, move the court to impose the appropriate sanction, which is to prohibit that part of the rebuttal testimony.
Okay, response from the state of Florida.
Your Honor, for the court's information, the documents that we intend to present are as follows. There is a one page to start with. There is a one-page document that is entitled Report for CMANTHON, which is the username. It's a login and logout report of a Unity system that is maintained by Gentiva, the employer of Ms. Anthony, for the week that begins March 17th of 2008 and ends on March 21st of 2008. That is a one-page document that we would be seeking to introduce. In addition, there is a series that begins with deleted emails of Ms. Anthony's, purporting to be Ms. Anthony's, for the week beginning the 17th and ending the 21st, Cindy Anthony.
Okay.
We have only asked for documents that pertain to those 2 days, Monday the 17th and Friday the 21st. We received what are labeled deleted emails, sent emails, and received emails for the dates in question. The largest document is a multi-page document. The reason it looks as big as it does is because it's an Excel spreadsheet that doesn't quite print in normal format, so it's broken up into two separate sections. But I will tell the court the broken up version is 232 pages, so half of that is about the length of the document. This is purported to be the work space or desktop login and activity of Cindy Anthony. It has the job entries, the job dates, the job time, the terminal at Gentiva that was used to produce these records, the username, and then additional information regarding patient activity, with the patient information removed because of the potential HIPAA implications of identifying those individuals. It is correct for Mr. Mason to say that Ms. Anthony talked about doing chlorophyll searches at her deposition in July of 2009. At that time, Mrs. Anthony did not extensively dispute the accuracy of her work records. In fact, during her testimony, she talked extensively here in court last week, and I believe that was last Thursday, about the fact that Gentiva would have these documents, that she didn't have access to them. She talked about passwords and computer activity during her testimony last week, that she didn't say one way or another necessarily would support or refute her in-court testimony. Of course, the court, as has been discussed throughout this case because of various hearings regarding discovery violations, knows that the sanction of exclusion is the ultimate sanction. I would note that the information was first requested from Gentiva through the Orange County Sheriff's Office upon inquiry by myself on June 24th, which would have been last Friday. They caused to have an investigative subpoena issued for any documents that could either support or refute Mrs. Anthony's claims. These documents, since they are separate types of records, came in pieces beginning the 27th of June, which would have been Monday, the 28th, and the 29th. They were sent electronically. I informed counsel yesterday morning that I didn't actually have the documents in hand. They were brought to me yesterday afternoon. I told them I would review them last night and provide a copy today, which I did. Mr. Camperlengo, that's Camperlengo, John Camperlengo, is the Chief Compliance Officer for Gentiva. He came here from Atlanta and is prepared to testify as the compliance officer and custodian of records as to the accuracy of these documents. Ms. Sims began an inquiry of him over the lunch hour and indicates that she needs some additional time to speak with him. That should cure any prejudice, if any, to counsel for the late receipt of these documents that was necessitated by Ms. Anthony's testimony last week.
Mr. Mason?
Your Honor, you have quite a number of times admonished all counsel that this is not to be a trial by ambush. Ms. Anthony gave the testimony 2 years ago. The state of Florida, with all its resources and its continuing investigation, explored everything. We took, after I joined this case last year, over 150 depositions. 27,000 plus pages of documents bait stamped by the state attorney's office have been provided to us. At no time in Ms. Anthony's deposition or inquiry was there ever an issue raised about the work records they're now seeking to introduce. She clearly testified about the issue of the chloroform and the search. We have, of course, the transcript of that from 2 years ago. The state should not be allowed to sit back and let Ms. Anthony testify on such an important issue and then spring on us in the 8th week of these proceedings witnesses to claim that she testified falsely. That is a discovery violation, I submit to Your Honor, that can only be met with saying, no, you don't get to do that. They suspected that she was not telling the truth about the computer searches, which was the record testimony, the only testimony on the subject matter, until she was testifying here in this courtroom. You must not reward the prosecution and support the prejudice in a capital murder case such as this. We urge you to realize this, in fact, is a discovery violation. It is material. We are prejudiced by the activities, and allowing Ms. Sims at a lunch hour to look at these 232 pages of printout and the other documents is just not adequate to get rid of that. I urge you to accept my or tennis motion now made to prohibit those witnesses from testifying or introducing any of those documents and records because of the clear discovery violation under 3.220 of the Florida Rules of Criminal Procedure and your specific and repeated orders and admonishments.
I have a question that I want both sides to address at the appropriate time. When Mrs. Anthony's deposition was given, did she give an indication, contest the validity of her employment records, which showed the various times that she was working?
I, with the court's permission, would refer to who was there at the time. And that would be Mr. Baez.
My recollection is, and of course we have it in another room and I can get that, is that we spent the majority of the inquiry talking about the computer searches and whether or not she ever searched for chloroform, how to make chloroform, things along those lines.
And what were her answers at that time during her deposition?
She did indicate that she made searches for chlorophyll, and the reason for that was because her dogs were, she suspected, chewing on bamboo leaves because they were acting lethargic. And so she wanted to figure out what the source of their malady may be.
I believe that that might not be complete, a complete response. I believe she did mention chloroform and also ingredients of such. If I can have just a moment, I can.
You may.
When asked, or chloroform by Miss Drain Burdick, Mrs. Anthony's response was, I may have. So she did answer to chloroform specifically, and then later on went to, mention, I believe, other areas. I don't want to, I'd rather give the exact testimony.
Of her deposition, beginning at line, it's cut off. Approximately line 22, where I ask, do you ever do Google searches on your computer? And then I said the desktop. And then we talked about the searches themselves rather than the work records that would negate her being home at the time of the searches in question.
Now, let me ask this question. The current records that you currently have, when did those records come into the state of Florida's possession?
Yesterday afternoon, the sheriff's office was gathering them over the course of Monday, Tuesday, and Wednesday.
And when did you notify the defense that you had those records and provided them copies of the records?
I notified them yesterday that I was expecting records from Gentiva. I may have indicated earlier this week that we were looking into having a custodian of records from Gentiva come to testify, but that I had not yet received any documents and that I would let them know when they actually arrived. And yesterday in court, they were brought to me.
Is this an issue that the state of Florida knew about back when you took the deposition, or is this a new issue that has arisen since Ms. Anthony testified?
I can say that I knew that she would testify to conducting chlorophyll searches. I did not anticipate that she would dispute the accuracy of her work records so extensively. She may have, and I haven't looked for it, she may have mentioned that she is a salaried employee and can come and go as she pleases during her deposition, but there was no further dispute to the extent that she testified to it last Thursday during cross-examination.
I would add that she did, in fact, say she searched chloroform, or she may have searched chloroform. And in just looking at page 152, I see where she writes, as to her answer, and possibly chloroform because my cocker and my Yorkies would eat a lot of bamboo leaves, and I know there's chlorophyll in those leaves, and they were getting sick, quite sick. And she also says a little further up on the page, on line 9 through 12, that she remembers looking up chlorophyll back in March, which are the key times of last year, and I'm not sure if I looked up chloroform as well. I looked up alcohol and several other things like that, like ethanol, alcohol, and peroxide too. And these searches, the alcohol and peroxide, they're also in the March timeframe. So.
Was there any awareness on part of the defense that Mrs. Anthony would testify that even though her work record showed that she was at work, that she would come in and say that those records are not accurate? and that it doesn't necessarily reflect that she was at work.
I think what we had here is we had the witness testifying to these searches in the March timeframe, which is specifically these items are what is in question. So to answer your question, she did say, as Ms. Drain-Burdick said, she was a salaried employee. Salaried employees come and go. So I think that we both expected her to testify that she did these searches.
I'm not talking about the searches. The question I asked was whether or not the defense was aware that she would come in and say, despite the time records showing that she was in fact at work, that those records were not accurate and in fact meaningless.
Yes, I think both sides were aware of that and expected her to testify to that. So yes.
And did she ever say that in her deposition or any sworn statement?
I believe Ms. Drain, when she stated that that was an area that she touched upon, it was, I would agree with her on that. How far she went into it, I do not know. It was Ms. Drain-Burdick's deposition. So that is, the answer is a kind of yes.
Okay. Other than the possibility of her testimony being impeached, what prejudice, if any, would the defense suffer if those records were brought in to contradict her testimony, if it in fact contradicts her testimony?
I think it would be, we would be severely punished because we are presenting or knowingly presenting false evidence. And that certainly is not something that the defense intended on doing. We took Mrs. Anthony's representations that she's a salaried employee and does not punch a clock, and that she ran these searches. And in fact, it was in the March timeframe with the exact items of what was done. So I don't think there is a remedy short of exclusion. Even if we were granted the ability to call Mrs. Anthony back on surrebuttal, what's to stop Mrs. Anthony from pleading the Fifth Amendment? Because now that opens up a whole area of other problems.
Well, she gets up here and plead the Fifth Amendment, then we'll deal with that. If we deal with that may, and I use the word may, cause all of her testimony to be stricken.
And there's another thing, Judge.
And the jury instructed to disregard. Okay.
There's another problem. I think this is way too late. We're right at the close of our case. Okay. We've rested, and they're now giving us these documents. We certainly could have attacked this evidence in another manner, or actually not. If this is in fact misleading the jury, that's not a stigma we want attached to the defense, that we are presenting false testimony. And that is where we are significantly prejudiced.
Unfortunately, neither the defense nor the state, unless some witness before they takes the stand tells you, I'm going to get up and lie, and then you put the witness on knowing that they will lie, that's when counsel gets into trouble. But unfortunately, counsel can only rely upon what witnesses tell them, and they cannot guarantee or warranty that witnesses will not necessarily go south or shade or change their testimony. Okay.
I would agree with Your Honor 100%, but I would reassert or bring to light what this court has often said when it comes to discovery violations. Did the offering party know or should have known that this was going to be an issue? And the obvious answer to that is yes. In fact, it's 2 years ago, yes. And we rest on that.
All right, last state, anything else you would like to say?
I believe the inquiry is whether or not it was intentional or willful, not whether or not it was some issue that could be contemplated as having come up. I believe that Ms. Anthony on the stand was trying to defend her position quite vigorously and started talking about emails at Gentiva and passwords and logins, and so we followed up on it. And I don't believe that there is any prejudice here. I would never argue that Mr. Baez was trying to dupe the jury by presenting this testimony. And at this juncture, I don't believe that they've established either that this was willful or anything other than inadvertent, that they got this as soon as I got it. I didn't even have our office number the discovery because that would have prolonged getting the information to them. So at this point, we would urge the court to find no discovery violation at all, and that the prejudice, if any, can be cured by counsel's speaking with Mr. Camperlengo, who is currently here in the jurisdiction.
That is not all we can do, Judge. These are computer documents, computer printouts and records, as we've seen in this case already. Sometimes computer documents and reports can be a bit misleading. We would need to have our expert go and look at see how these documents are compiled, and if this is a true and accurate reflection of those types of records. This is no simple issue. This is one that is complex, that is a stack of documents that the state this morning decides to drop on us, like, okay, here you go. And I think that the timing is way too late.
Well, let me ask you this last question. Before Miss Cynthia Anthony took the stand, did you know she was going to say what she said about the fact that she was at home and not at work, as her employment records would indicate?
As the records that we had in the discovery, yes. And in fact, they were already in evidence. So yes, they are in. The work records are not something that we've disputed. And the counsel is still free to argue, look, her work records show her at work at this time, but to go ahead and bring in new stuff that we haven't had the ability to verify the veracity of.
Well, let me rephrase my question. Were you aware when Miss Anthony took the stand, she was going to testify that despite the fact that the records showed that she was at work, that those work records were meaningless?
Yes, sir. And any further testimony that Ms. Drain just finished arguing about, these were statements that she elicited during the process of cross-examination, knowing full well that was what she intended on doing.
Okay. But you knew she was going to testify to that?
Yes, sir.
Okay. Now, the work records that were introduced, were those work records computer generated?
They appear to be, yes.
I didn't do discovery. I'm asking y'all. Y'all did it.
It's a time card history report, so yes.
Was it generated by the use of a computer?
Yes,
Or were they
it's not
or were they manually done?
No, it's computer generated.
Now, were there any indications on those records where someone had an expert to look at those records to see if anyone had tampered or monkeyed with the computer program to bring in or question the accuracy of those records?
No, sir, and we actually engaged in a stipulation regarding the accuracy and admissibility.
And that would be because both parties knew she was a salaried employee who did not punch a clock. So those records are of limited value. And that is why, knowing full well what the work records show, we believed that there was an explanation that Mrs. Anthony could give as to why she ran those searches. So it was, we know that this is the good and this is the bad, and we could basically compare the two, and if she can explain it, perfect. And that's exactly what she did on the stand. She didn't go any further. She didn't take it any further as far as her direct examination was concerned. And that is when the state decided to go out and elicit more information and then just go ahead and introduce these new records.
Anything else from either side?
Not at this time, Your Honor.
Mr. Baez? Pursuant to Richardson versus State, the court will make the following finding of fact. The court will find that this was not a discovery violation. As soon as these particular records became pertinent, the state of Florida sought those records and provided those records to the defense. The defense raises the issue of prejudice. Trials are supposed to be about a search for the truth. Juries are supposed to be given sufficient evidence so that the jury can take the law, apply it against the facts, and speaks a verdict that renders the truth. The court will instruct this jury certain factors dealing with the credibility or believability of witnesses. As I've indicated earlier, they will be instructed that they can believe or disbelieve all or any part of any witness's testimony. The remaining question is how much time does the defense need to adequately review these records and be prepared to effectively and intelligently cross-examine the witness who will be presenting this testimony. The defense has indicated that they need their, quote, computer expert to look at all of this and to authenticate these records. But from what both sides have done in this trial, they have stipulated from records from this organization, and there is no evidence at this time that the prior records or these records are a result of a fabrication. Both sides know the penalty for fabrication of records. Fabrication of records, if it is proven at any point in time, would be subject to having whatever happens in this case thrown out. That's provided there is a verdict of guilty. If not, then you never get to that particular question. I understand this gentleman has a problem, but unfortunately, in fairness to the defense, I'm going to give them the balance of the day to have Ms. Sims talk with him Ms. Sims, how much time you going to need to talk with this gentleman? You know, we can take more time than what we need. You've heard this gentleman needs to be back for a doctor's appointment. If necessary, I will make him miss his doctor's appointment, which that's if you need the time. I mean, everyone knew this was coming based upon Mrs. Anthony's testimony. I don't think it is any big surprise that somebody was not going to go out and get these particular records. But as an officer of the court, consistent with the oath that you took when you raised your hand and was sworn in as a Florida bar member, how much time do you need to do what you need to do?
Well, I started speaking with the first gentleman, and I'm not really sure. I would like to think that it's a little confusing because this came from a backup tape and there's times that are different and converted. I would hope within an hour or so. And then there apparently is another computer expert. I'm not really sure. I don't know because I haven't spoken with that individual. I just don't know. This from Gentiva, I'm sorry.
What she's talking about is that the chief compliance officer, as custodian of the record, had somebody else compile the information. So if there's an individual, she got the name, that assisted in compiling the information, I suppose they could talk to that person who would presumably just say, I received this directive from the chief compliance officer and produced these documents. Because of the age of the documents, what he has told her so far, as I understand it, is that they are stored somewhere else and then had to be retrieved. The only time difference is that their server is in Kansas City, and so the times are Central Time, which he can explain.
Well, I don't know what the time differences are referring to, and these were obtained from a backup tape and then converted. And if I can get that individual on the phone and try to ask about the conversion and have our expert walk me through some of this, this is a little bit above my abilities, but I'm willing to go out right now and start working on it, Your Honor.
Well, the state sort of enlightened me in a little bit more detail concerning this witness's medical issues and why he needs to be back in Atlanta and why he cannot delay that appointment.
I'll go find out, Judge.
Okay. And if the appointment is at 7:45 in the morning, could not he make his appointment? There are several flights from Atlanta back to Orlando where he could testify in the afternoon. Court will be at ease. Okay, who will be the state's witness?
Alina Burrows.
Okay. All right, let's return to jury.
Before we do that, just before we do that, in the interest of efficiency, there was an issue
Wait till you hear the
about.
other door close.
Somebody needs to go over this.
Sorry. Just in the interest of efficiency, the first witness is going to be about 30 seconds. The next witness deals with an issue that I understand counsel wants to raise an objection to, so I thought if the court wanted to do that now rather than having 30 seconds in and then out again.
Let's take care of that.
The next witness after the second witness will be Mike Vincent. I propose to ask him to bring out from him that he examined State's Exhibit, State's Exhibit in Evidence 322 on the I believe it was May 2nd is the date he would say, at my request, that he opened it, that his testimony would be that the odor that is retained in the can is the same odor with less intensity than the odor that existed in the trunk of the car. That is all the testimony I would plan to offer from him. But since it somewhat goes to an issue that we talked about 6 weeks ago at jury selection, I told counsel so he can raise whatever objections he wants in a more orderly fashion.
First, I think the court needs to evaluate what this is in rebuttal.
What does it rebut?
Yes.
The testimony of particularly defense witness Furton, who suggested that the odor in the trunk came from the trash. And let me tell you what I'm doing here.
Okay.
This jury, in my estimation, is going to want to smell the evidence. When we passed around one of the items from the garbage, as counsel pointed out, one or two of the jurors on their own sniffed the evidence. The smell of this evidence has been the feature of this whole thing. So this jury is going to want to do that. I'm not necessarily going to ask them to do that, but we got to be realistic. They're going to want to do it, and we're going to need to determine how we deal with that. And part of the predicate, obviously, for their ability to do that is to know that the smell in the can is the same smell it was in the car. That's why I'm putting Vincent on. And I don't know if the court now wants to address whether they will be permitted to use their olfactory sense to examine the evidence. So we're somewhat premature, but since it's related, that's why I brought it up. I mean, obviously the testimony is admissible. It's just an observation by the witness. And I don't know if the court wants to address the next level of that issue, which is whether the jurors can smell it and under what circumstances. So that's sort of where we are right now.
Mr. Baez?
Yes, sir. While we're still on the rebuttal issue, Dr. Furton was asked specifically by Mr. Ashton if he had ever smelled the trash or the carpet, and he said no. So there's nothing to rebut.
If the defense is conceding that they are not going to argue in this case that the odor in the trunk of that car came from the trash, then you're right, I have nothing to rebut. But realistically, Judge, we know that's what they're going to do. The defense has done this through numerous witnesses. Dr. Furton was placed before this jury for the express purpose of testifying to support the argument that the smell is from the trash. And that's where we are. And
well, how many witnesses did you put on and testify that it was not from the trash, that specifically said it was the odor of human decomposition in their estimation?
I think probably at least 4, perhaps 5, and one witness who I believe testified it smelled to her most like rotting flesh. So there have been numerous witnesses that have testified that in their opinion, it smells like decomposition. Each one of those witnesses was cross-examined vigorously about that issue. And the defense actually cross-examined a number of those witnesses about earlier statements that they had made attributing the smell to trash, including, most recently, George Anthony. So I anticipate the defense is going to continue to attempt to convince this jury that that odor came from the trash in the trunk of that car.
But isn't that a jury question, since you've had testimony from Furton saying that it was not, and you've had a fair number of individuals from the state side that has testified that in their estimation, it was human decomposition. You've had Dr. Vass, who's testified that he smelled it. It was the odor of human decomposition, and that even his testing said it was consistent with human decomposition. I'm trying to figure out what does that rebut. To me, it doesn't rebut anything.
Well, there's sort of 2 levels to the question. It rebuts the direct testimony that the smell in the can is the same smell as before is combined with the examination of the item itself by the jury to show that it's not from the trash. The question is, right now, what are we going to do when this jury asks to smell the items in the carpet?
You want them to smell it,
what are we
Mr. You want them to smell it, Mr. Baez? Do you want the jury to open the can up in the jury room and smell it?
And I would ask that the court review Huff versus State as well as Clark versus State.
I'm ready to address it.
Go ahead.
The issue in Huff and Clark is where you have a single juror gaining some experience with an item and then telling other jurors what their interpretation of it is. And I agree that in this circumstance, we should not simply send the evidence back because one of them may pop it open, smell it, and give their opinions to the others. That would absolutely be prohibited. We shouldn't do it. But those cases do not hold for the proposition that jurors can't use their sense of smell in examining evidence. And that's really the only issue here. If this juror asks to smell this evidence, are we going to tell them, no, you cannot use your olfactory sense to examine this evidence? And quite frankly, Judge, I can find no legal support for the proposition that they can't. There are a few cases I have found that seem to discuss the issue of using the olfactory sense of jurors in deciding cases. One of them, and I have copies for the court and counsel, is Decker versus Knowles, which is a 2009 opinion from United States District Court, Eastern District of California. I only have a Westlaw site, 2009 WL 2985493. This case involved a situation where the jurors on their own during deliberation sort of smelled some, I think, marijuana evidence that was placed before them, and there was a question before the court as to whether that was improper. The holding of the court, and I'll give the cases. And the partial holding of the court, at least relevant to us, is that the juror's use of the olfactory sense was not improper. Ingram versus Texas, let me see, is that the next one? Let's see. Oh, no, Ingram's not the next one. The next case I have is Washington versus Fairbanks, found at 118 Washington Appeals 1037. This is a case out of the Court of Appeals of Washington in which the issue was the prosecutor in a marijuana case. There was an issue about officers testifying that the odor of fresh marijuana had a certain distinctive quality to it, or a quality that they recognized. In fact, let me give you the case as well before I talk about them. In Fairbanks, the prosecution brought in a bag of fresh marijuana as a demonstrative exhibit in order to give the jury a sense of what fresh marijuana smelled like. And the question in Washington versus Fairbanks was whether that was appropriate. And the court in Fairbanks indicated that it was appropriate. Again, further sort of supporting my argument that, in fact, the use of the sense of smell is appropriate. There are, I haven't copied them all, but there are legions of cases from the 1920s and 1930s involving prohibition, where jurors were permitted to smell, even taste contested substances as proof that they were, in fact, liquor. So in this case, and we're somewhat jumping the gun because the jury hasn't asked yet, but if the jury does ask to sample this evidence using their olfactory sense along with their sense of touch and sense of sight and every other sense that they have, I can't find anything that would prohibit them from doing that. Now, obviously, if they do it, each of them must examine it equally. So if they make this request, I believe they would have to be instructed to come out. the cans would be passed to them, and they each must smell it individually so that we avoid the Clark problem of one juror experiencing something and telling the others what it is, which would be a very serious problem. But I cannot find any case law that would support the defense's contention that for some reason the olfactory sense is prohibited when the other senses are not. But again, the testimony of Mike Vincent is simply to sort of give us, to eliminate one possible objection to them doing that, and that would be that it doesn't smell the same. He would testify that it does. That's all I have.
It appears that my colleague, Mr. Ashton, didn't understand your instructions during jury selection. Your Honor had suggested to the prosecution, if this is something they wanted to do, that they would have to provide case law that was specific and on point. Doesn't necessarily mean getting a marijuana case from California or Guam to try and come in and support a position like this. We have here a situation where this is not an everyday, normal, common experience as recognized by 701.1. The court was clear during jury selection what the issue was. He had instructed the prosecution to provide something. They never did. Now here we are at the end of trial, very close near the end of trial, and they want to try again. There's nothing that Mr. Ashton has presented that should give guidance to the court that for the first time in the state of Florida, a jury should be able to smell something and become witnesses as to the smell of human decomposition. And I don't know if juror number 1 has experience and juror number 7 does not, because I think the court nipped this in the bud very early on. And does that mean now that we have a jury of 6 or 4, of 3 or of 2? We don't know. And certainly an attempt to try and introduce something as novel as this would significantly prejudice us at this point. We can't start changing the rules in the middle of the game. And that is essentially what the state wants to do here. We knew about this problem during jury selection. We couldn't provide you with any case law on point. And at the end of the day, right towards the end of the trial, we'll try again and hope that the judge will change his mind without any support or authority.
Okay, thank you, folks.
Can I also add another point? Under the Fairbanks case, which is, I don't know what state this is in, Washington, the defense opened the door. That's no such situation here in this case. The prosecution has had ample witnesses come and testify about the smell. And again, they are attempting to make these jurors witnesses. And I would also submit that this is not a published case either. The second Decker case.
Okay, thank you, folks. The court raised this issue when we were in jury selection, and the court called everyone's attention to a case out of the state of Texas, Smith versus State, found that 214 Southwest 2nd 471, a 1948 decision from the Texas Criminal Court of Appeals, where they said the following. The question is not a new one. It has been before this court a great many times and has been the cause of reversal over a long period of time. The Court of Criminal Appeals has condemned the practice of having jurors, at the state's request, smell, or taste whiskey because it calls upon them to be witnesses on a disputed issue. And when doing deliberations, a juror stated that it smelled or tastes liquid was whiskey, his statements constitutes new evidence received in retirement. That was the case that I told y'all about back in Clearwater. The court also talked about the case of Decker versus Knowles. And there was a case out of the Supreme Court of New Mexico. Which said you could do it. And if I remember correctly, it was a case dealing with the smell of alcohol, commonly known as whiskey, beer. And these were things that traditionally were within the realm of ordinary human knowledge as to what beer or adult alcoholic beverages would smell like. There are two cases in the state of Florida that has sort of dealt with this issue, and it is basically labeled also jury experimentation. The latest case comes from the Florida Supreme Court in the case of Lynch versus State, second edition, no, 2/7 third edition, page 47. That was a case that was a Def 3851 case that was presided over by the eminent jurist O.H. Eden. The defense found fault with Judge Eden going back and looking at an item of evidence since he was the trial fact, which was a Glock G30 weapon. And Judge Eden was basically trying to see if what the firearms expert testified to was consistent with his manipulation of the weapon. And the court basically said and drew a narrow distinction in that case because it was a non-scientific conclusion. Contained, though, in the Lynch case was a cite from the 4th District Court of Appeals found at 972 7 2nd 254 Castillo versus Vision Health and Surgical Center. And they talked about so-called jury experimentation. In the head note, it says that the trial court did not abuse its discretion in a medical malpractice action arising when a surgeon left fragments of a sponge in the patient's eye following surgery to remove a certain malady by allowing the deliberating jury to replicate a demonstration done by the defense expert at trial, in which the expert had placed a sponge like the one used by the surgeon in water to show how the sponge expanded. What they concluded was replication of a demonstration that was demonstrated in court was not new extrinsic evidence. In this particular case, if the jury is allowed to go back and open up a can and smell it, what would they be smelling it to determine? Are we asking them to become witnesses to make a decision whether or not, in their estimation, and sit down, Mr. Ashton, I'm not finished talking. No, sir.
Apologize.
I know. Are we asking them the question, you determine based upon your own senses, whether it's trash, or we are asking them to say whether it is the scent of a decomposing body, when in jury selection, there were about 3 or 4 potential jurors who did say they had smelled the odor, but without going back and examining all of the transcripts, I can't remember whether one of those jurors survived and is on this jury. There's a possibility that one is. How would the defense be able to cross-examine that particular juror or determine what sway that juror would have on the other jurors? To permit the jury to open a can up and one juror who may have had experience say, that's it. That's the odor of decomposition would, in my estimation, be new extrinsic evidence and would violate Mrs. Anthony's due process rights and deny her Sixth Amendment right under the United States Constitution to confront witnesses against her because she has absolutely no ability to confront that juror, to cross-examine that juror. Therefore, the request, if made by the jury, and the court will make the following ruling. That particular item of evidence will not go back to the jury. I am well aware of the rule of criminal procedure that says that all items introduced into evidence can go back there, but judges are not supposed to be potted plants. Thus, the court will exercise its discretion and not allow any, quote, smell tests by jurors. There has been ample testimony, including what Mr. Baez would loosely call cutting edge or voodoo science, depending on which side of the aisle you're on. If you're on the state's aisle, it's cutting edge. If you're on Mr. Baez's side of the street, it's voodoo science. There's been ample evidence for this jury to determine from witnesses who were subject to cross-examination as to what they thought that odor was. The testimony by Detective Vinson is not rebuttal, and the court will not permit his testimony. So I take it we have this statement, and if you don't have any more witnesses for the day, I can understand.
We can introduce these photos and some documents and then deal with the other issue with the Gentile records for the balance of the day and present that testimony in the morning.
Okay, then we'll bring those jurors in. We'll take care of that brief testimony, and then I will let y'all hammer out those other issues. Anybody need any break before we bring them in?
Sure where Mr. George is, since
Okay, what we'll do is take a 5-minute break so everybody can get what they need to do, and we'll get started. Yes, sir.
Maybe one issue that we would want to address with the Gentiva issue.
We can do that after we take care of these jurors.
Oh, okay. That's fine. That's fine, sir.
I want to get them in, get them out, send them on their way, and rather than have them held captive back in that little room. Okay, we'll take 5 minutes.